Okay. Доброе утро, дамы и господа.
Good morning, ladies and gentlemen. Good morning, dear colleagues. So I will both speak in Russian and in English. So let me introduce myself. My name is Glenn Kalini. I'm a senior partner in Denton's legal firm. I am based in Moscow. And I have to tell you that previously, I've been working for 10 years. I used to be the head of our St. Petersburg branch. This is my 5th time that I'm participating in the forum, and this is my 3rd time as an organizer and the moderator of the session on pro bono.
Although there is translators, my name is Glenn Kalini. I'm a senior partner of the Denton's law firm based in the Moscow office. I've been living in Russia for 16 years, and I'm admitted to the bar in the state of New York and in Leningrad Oblast. This is the 3rd time that I've been asked to, or had the honor, I would say, to organize the session on pro bono at the St. Petersburg International Legal Forum. And we have a very distinguished panel today. I'll just very, very briefly introduce the panelists. I believe that the biographies of all of the members of the panel, with one exception, which I'll come to, are in the booklet that all of you have probably received. So just to quickly introduce the members of our panel, starting from left to right. First is Dmitry Samigulin. Dmitry is the managing partner of the RBL law firm, one of the leading law firms, not only in the city of Samara, but in all of the Russian Federation. Dmitry is very active in the area of pro bono and has received a commendation from the journal Legal Insight for one of the pro bono projects that they undertook several years ago. Next to me on my left is Senator Konstantin Dobrinin, a member of the Federation Council of the Russian Federation, also a lawyer and formerly managing partner of a St. Petersburg law firm called Pen and Paper. On my right, those of you who attended the prior session will recall Christos Giacomopoulou, from the Council of Europe. Sorry, I didn't do that as well as I had hoped. Christos is the Director of Human Rights for the Council of Europe. And next to Christos is Kendall Coffey. Kendall is Managing Partner of the law firm of Coffey and Burlington in Miami, Florida. He's a former prosecutor and a federal prosecutor, the U.S. Attorney for the Southern District of Florida, and really one of the leading lawyers in the state of Florida in the U.S. And then we have Ozgur Kahale. I hope I pronounced that right as well. Ozgur is a very extremely interesting person we're very glad to have with us today. She's a member of DLA Piper, based in their Istanbul office, and is unique on our panel today because, if I'm not mistaken, Ozgur is not an attorney. You are an attorney, I'm sorry about that. But in any case, Ozgur's role at DLA is to coordinate pro bono for the offices in Europe, something I should say that I've become somewhat envious of and hope that our firm will follow in their footsteps. And finally, last but not least, Dmitry Shabelnikov, who in many respects has done more for pro bono in Russia than any other person, and heads the Moscow office of an international organization that is playing a critical role in the area of pro bono called PeelNet. So what we'd like to do this morning, we have a number of questions that have been published on our site in which we will try to answer or address. in a more or less roundtable fashion. Primarily during our discussion this morning, we will permit questions at any time. So especially given that we had a late start, we don't have any formality, and if you feel the need to ask a question in the middle of someone's presentation or statement, just raise your hand or nod in my direction and I will then recognize you. And we'd like to start off with a few words by Christos Giankomopoulos, who will talk a little bit about the significance of the agreement that was just discussed in the prior session and the difference between pro bono legal services and legal aid and what questions that raises. So let me hand the floor over to you, Christos.
Thank you very much, Glenn. Some of you have been here before, so you have heard about this project that the Council of Europe is launching together with the Ministry of Justice and with the support of the government of Luxembourg concerning the implementation of the Russian federal law on free legal aid. I said during this launching event that there is a link, some link at least, with the pro bono legal services. And I will try to explain a little bit how we see this link. I know that most of you are involved in the pro bono legal services from the private initiative sector, and my position, my presentation will try to link this extraordinary development of the pro bono legal services all over the world with the responsibility of the state towards its own citizens and the international responsibility of the state. So my approach will be a state-centered approach rather than the private one. So I would make 4 or 5 points, so I will not monopolize at all the discussion. There is an obligation by the state to provide free legal aid, in particular under the human rights law in criminal cases. This is established. It is an obligation of the state to provide legal aid in criminal cases. In the development of the human rights law, there has the obligation of the state has extended beyond the criminal law sphere through the area judgment of the European Court of Human Rights, to which my colleague Francesco Crisafulli has referred in the previous session. The court has indicated, the European Court of Human Rights has indicated that there is an obligation of the state to provide legal aid in civil and administrative cases in order to secure equality of arms and access to justice for people who are disadvantaged for any reason, in particular for economic reasons. So the human rights and criminal procedure law obligation of the state to provide, to facilitate access to justice and to secure equality of arms and a good management of justice in criminal law is progressively extending to other areas, civil, administrative, possibly commercial. There is another development which is much more recent, and this has to do with the need to secure individual rights, in order to secure individual rights, to have a procedural aspect to the substantive rights. You have a right to privacy, for instance, and this right to privacy in modern human rights law has a procedural dimension. It has a procedural dimension in the sense that you must have not only the right to privacy, but also the right to claim your privacy. And this is what in human rights law we call the effectiveness of remedies concerning human rights protection. And the effective remedies that states have to provide relates also to the accessibility. These remedies, in order to be effective, need to be accessible, and they need to be provide, to have results. And there is where there is a huge development of the pro bono legal services, which is combined somehow with the obligation of the states to secure the effectiveness, the accessibility of these remedies. Now, where the problems come, there are problems nonetheless, because of course the state, when it has the obligation to provide remedies, to provide access to remedies, to provide legal aid, can possibly rely in the existence of pro bono legal services offered by legal firms, by law firms. It can also rely on NGOs who provide also pro bono legal services to some people, depending on the objectives of the NGO. It can also rely on the fact that there exist legal clinics who also provide legal services and who can secure the effective access to those remedies. But at the same time, this is transposing the state responsibility to the private sector, law firms, NGOs, legal clinics. To what extent this is possible and what are the responsibilities of the state in this respect is a very tricky matter. In the criminal law field, the state has a responsibility not only about the quality of the services provided. We have cases in which the European Court of Human Rights found in criminal cases, I repeat, in criminal cases, that the legal aid that was provided was not effective, and therefore the state has failed to its obligation to provide the access to justice or to secure the rights of the defense in criminal matters, when, for instance, the lawyer that was appointed has not performed properly. There are also cases in which the court, again, the European Court of Human Rights, found that the fact that the state does not pay the lawyer who has defended, or does not pay on time, the lawyer who has defended an accused, still on criminal cases, creates a violation of the right of the obligation to prohibit forced labor. It's a tricky issue. We can come back to that on some occasions through the discussion. But there are also cases in which the court has admitted that the state, in order to secure the quality, can also impose a choice as to the defense lawyer, and has, for instance, can impose a lawyer to an accused who does not want any lawyer and wants to defend himself alone. So when the state has the responsibility, it has also some rights in order to secure this responsibility. How does this work when the state relies on pro bono services? What is the degree of regulation that the state can have on the pro bono legal services? What is the degree of interference of the state in the provision of pro bono legal services? I would say that there is a gray zone in which, for the time being, the state authorities rely essentially on pro bono legal services in order to, let's say, remove their responsibility to the private sector, but at the same time, they may have an interest in regulating in a specific way, which does not necessarily comply with what we call pro bono legal services and the intention of the pro bono legal services, whether they come from law firms, from the NGOs who have specific interests, or from legal clinics. So I would say that there is an area, gray zone, where these two issues are combined, and where I believe there is an enormous room, in view of the dramatic expansion of the phenomenon, increasingly in Europe, but I believe also elsewhere in the world too, to see what are the relations, what are the limits, what are the limits at least of the state responsibility. And because I don't think that there is any responsibility on the behalf of the pro bono legal services, at least at the level of international human rights law. I will stop here, Glenn, and I think that some of the issues that I have raised, to which I have no answer whatsoever, will be addressed during this discussion. Thank you so much.
Thank you, Christos. I guess I'll start with a quick comment or question. And of course, the issue of the state's responsibility and the responsibility of the private bar, where to draw the line between those, is a very difficult one. And there is a concern that if the bar were to, in effect, step up to the plate and take on a greater role, that this would in effect relieve the government of its responsibility, a legal responsibility, to provide, for instance, free legal services for indigents in criminal matters. On the other hand, in many respects, pro bono can complement the provision of legal aid or free legal services to indigents. For instance, in the United States, we have, of course, legal aid for criminal matters, and nonetheless, many law firms participate in criminal defense on a pro bono basis, so particularly in capital cases where a sentence of the death penalty has been imposed. In many respects, there's almost an implication that if the death penalty has been imposed, that a lawyer that was appointed through the legal aid system or through the court has made a mistake or has failed to adequately represent the client. I guess there might be a theoretical case, perhaps the Boston Marathon one is one, although personally I don't think that is, where even the most optimal defense could not result in a sentence of less than the death sentence. But in most cases there are errors, and these are then handled by law firms with a rather high rate of success. So in addition to its primary missions, I would say the pro bono can supplement legal aid, but it has to be done carefully, of course, to maintain very high quality standards, particularly when we're talking about serious criminal cases, and to assure that the interface, let's call it, between government-supported legal services for indigents and the services that are provided by independent lawyers, law firms, and also corporate legal departments can complement and extend the reach of those services. Does anyone else in the audience or the panel want to discuss this? I think then we will turn to Dmitry Shabelnikov, and Dmitry will give a sort of overview of the issues on globalization, together with some slides and pictures of how the globe is dividing up. And I think that'll be a good way to lead into the rest of our discussion.
Thank you, Glenn. I'm really the only person from our group who couldn't refrain from showing several slides to you. I think that they will be quite helpful in this discussion to us. My organization in the last 10 years has been promoting pro bono in different countries of the world, and I will show the definition of pro bono from one of the international documents of the International Bar Association, IBA. And quite often my colleagues and myself at different continents heard pro bono is an American story. We will never have, and we never had pro bono. And then different arguments were provided, starting from the fact that we have a very good system of subsidizing legal aid, and we didn't need pro bono, and we don't want commercial lawyers to take bread away from the lawyers who are dealing with subsidizing legal aid. And another argument in other countries was that we have a small market of legal services. The lawyers are poor, they cannot provide free legal aid, and it will never happen. And another possible option, we really provide free legal aid, but in our country we should never boast of this. So we are not calling it pro bono, and we are going to do it further, and you shouldn't tell us all these stories. I will try to answer the questions. And before I'm doing it, I will make some statements. In Germany, until recently, legislation prohibited rendering free legal aid outside the system of subsidized legal aid for certain historical reasons and other reasons. For instance, it was not permitted to have unfair competition among the lawyers. In Brazil, local bar association prohibited their members to render pro bono assistance on the grounds that I have mentioned, that there is a system legal aid that is not quite operational in Brazil, and that's why it was not allowed. So to a certain extent, in a certain sense, this statement saying that this is an American, problem, it is true to a certain extent, but lately many things have changed. And I will try to answer the question whether we can say that pro bono is becoming a global phenomenon or has already become a global phenomenon, and how and why. And in this sense, according to my observations, there are two parallel flows or aspects of globalizations, which I call globalization from the outside and globalization from the inside. When I'm speaking about globalization from the outside, I'm speaking about the so-called global law firms. This is the information from the rating of the German journal American Law, just to show that 100 largest global law firms that have offices not only in their origin country, though among these 100 companies, there are 70 Americans and 13 UK companies, that there's a large army with a lot of money and human resources, at least 100,000 lawyers in 100 largest firms.
As I've said before, most of these firms are American firms, and I have to say that for the last 20 years, if I'm not mistaken, what is happening in America, or what exists in America, is a pro bono challenge initiative. This is a project which was implemented by the Pro Bono Institute, and it is a true challenge, because any legal firm, any law firm that signs these pro bono channels assumes the responsibility, which means that it will spend at least 3% of their billable hours, or 5% of their billable hours on pro bono cases, or 60 or 100 hours per year per one lawyer. And this was true for American firms. But until recently, that was only true for the American offices of these law firms, and not for their overseas offices. But as the director of the Pro Bono Institute told me, what we have today is that we have at least 2 law firms which submit reports across all of their offices, and they use the Pro Bono challenge in all of their offices globally. So I think it is an emerging trend, but it hasn't been published officially by the Pro Bono Institute, since it was their individual initiative, 2 firms out of 150. So the American Lawyer Journal, which I've mentioned before, basically had a survey in 2014. This was the first survey of its kind. So they surveyed about 100 largest American firms, which have representative offices overseas. So basically they surveyed 87 firms, and only 30 firms responded to the questionnaires that were sent to them. And it turned out that some of these firms spent from 20 to 40 hours per lawyer on pro bono cases, which is 2 or 3 times less than the time that their lawyers dedicate to pro bono cases in their American offices. So the average correlation or ratio between American offices and overseas offices, 62 hours to 17 hours. And when we're talking about non-American firms, this ratio is even lower. But again, I have to say that this was the first survey of its kind, so it wasn't truly representative due to a number of reasons. Maybe the methodology wasn't developed up to a standard, but still it gives us some food for thought. And I think that is not accidental that, again, 2014 was the year when Trust Law conducted their first similar survey, and as you know, Trust Law also promotes pro bono on the global platform. So they surveyed different firms in all over the world, from small law firms to large firms, 69 countries, 103 firms, employing about 36,000 lawyers, and all of these firms spent about 1.5 million hours on pro bono cases, which is quite impressive. But if we look at different regions, then the picture is not as rosy. As you can see on the slide, we have the number of hours that firms spent on pro bono cases. So the United States is number one, 75 hours, then Australia 44.7, and in brackets you have the share of lawyers who personally spent more than 10 hours per year working on pro bono cases. This is a very important indicator as well. It does happen often that a lot of pro bono cases are worked on by young lawyers, but senior partners usually say that it is young lawyers who work on pro bono cases in our firms. But I do know that some law firms, for instance, Deckert, which was probably the first global firm which made it mandatory for the lawyers to dedicate a minimum number of hours for pro bono work. I think it was 25 hours, if I'm not mistaken. So I would say that some legal firms have a culture to provide pro bono legal aid, and it is not provided just by young lawyers but also by senior partners. So I think that concludes the part of my presentation on global firms. But let me just give you an example of a law firm which was a pioneer in this field. But there another aspect of pro bono globalization, the globalization which is happening from the inside. As you know, there were a number of declarations that were signed in 2008, like IBA Pro Bono Declaration or Pro Bono Declaration of the Americas. They do not really carry a lot of weight in terms of their practical applications, but they do provide a lot of support to pro bono principles from the governments, from the judicial organs, and so on. Basically, this declaration states that we are going to provide support to the poor, to socially vulnerable populations, and I do believe that these declarations really do help to popularize the idea of pro bono. Apart from this, there are also, as I mentioned, Pro Bono Declaration of the Americas and the IBA Pro Bono Declaration. So these two documents also contain the recommendation on the required number of hours that should be dedicated to pro bono cases. But let me stress one more time, they do not really give us any real implementation mechanism. Usually, we can say that pro bono work is done actively in a country by a number of projects which play an intermediary role. These projects, well, I usually call them coordination pro bono centers. So I try to come up with a map, and you see that highlighted in blue. These are pro bono clearing centers where the demand and supply can basically meet. So you see it exists in quite a lot of countries where pro bono services are provided. So if you look at the map on Europe, then the picture again is quite interesting. There are two countries where pro bono projects do not exist. It's Northern Europe or Scandinavian countries and the Southern Europe, and probably the reasons are quite different. Probably in Northern Europe it happens because they have a well-functioning subsidized legal help. They have very well-developed social protection and social warranties. But if we talk about the Balkans, Greece, Italy, where such projects do not exist, although we've seen several attempts to initiate such projects, but it probably happens due to the infancy of the legal services markets and due to the lack of tradition. And I do believe that we are going to see a change when it comes to this situation, because again, like I said, there's quite a need for these services in the south of Europe. So if I talk about our organization, then I have to say that we also have several projects, several pro bono projects. One of them is in Russia. So this is just a brief summary of the project, and what makes us stand out among other projects is that we decided that we will provide help only to NGOs and not to individuals. So we provide support to the NGOs, and they in turn support the poor, the socially vulnerable, and so on and so forth. So you see the statistical information on the screen. The pie chart represents which organizations usually contact us. Well, organizations that provide support to children, that provides healthcare services, provide support to the disabled, cultural organizations, educational organizations, social protection associations. At the same time, the requests that they usually submit to us is something that the commercial lawyers would call corporate law. Sometimes this is something that's they cannot really tackle on their own because it is quite complex, and they do not really have the budget to reimburse lawyers. So basically, I tried to summarize what's happening in pro bono globalization, the internal and external globalization. Our organization does facilitate the meeting of these external and internal drivers. We are going to there will be the 9th European Pro Bono Forum in Rome. And last year we started to organize the Asian Pro Bono Forum. So last year it was held in Hong Kong, and this year it will be held in Bangkok in June. So I would like to share our plans with you. Next year in spring, we would like to organize the first Russian Pro Bono Forum, and I do hope that I'll see all of you there. Thank you very much.
Thank you very much. And I particularly enjoyed the concluding sentence about the Pro Bono Forum, which we hope to have for the first time in Russia next spring. And I've had a number of discussions with Dmitry about that. I think it's an extremely exciting initiative. And I hope that all of you who are interested in this area will contact Dmitry and will participate in making that forum a very big success. I don't see any questions. I think I'm going to turn immediately to our next speaker, who will also say a few brief remarks, and then we'll go into more of a roundtable format. Our next speaker is Konstantin Dobrynin, as mentioned from the Federation Council, Senator Dobrynin, and the floor is yours.
Dear colleagues, good morning, first of all. I would like to greet you here on behalf of the upper chamber of the Russian government, and I would like to thank Glenn personally that he invited me to participate in this roundtable discussion. I am not indifferent to this subject because, again, the pro bono topic is very relevant for this country. Well, since we are meeting for the third time to discuss pro bono as part of this forum, well, this is very commendable, but of course it is not enough. But I think we have to discuss pro bono almost daily because we live in Russia. We announced our topic as pro bono globalization, which is of course exciting, but if we keep in mind that we're mostly talking about Russia, I would say that we're getting a little bit ahead of ourselves, and let me explain why. If you remember 100 years ago, the economy in Russia was doing quite well, even without oil exports. But at the same time, basically the majority of people in the country were illiterate. Almost 95% of the people were illiterate. That's why the Bolsheviks believed that the cultural and the educational revolution, apart from collectivization and industrialization, was extremely important for the country. And I have to say that in the last 100 years, they did manage to achieve quite a bit when it comes to the overall development of culture. I do think that the situation is not so bad in the country with culture today, but at the same time, if we start talking population about the culture of law, then we have to admit that the level of legal illiteracy in Russia is almost the same as it was 100 years ago. And I think that we are also guilty here as lawyers, because we monopolized the right to law. It is always better, how they say, to sell the fish to sell fishing rods. And if we talk about the citizens of our country, first of all, they completely do not know their rights. They do not know the mechanisms that they can use to protect their rights. And I think that it is very important for our citizens to understand that we have laws in this country, and these laws have to be obeyed. Unfortunately, we have quite a big problem with that in this country today. Why did it happen to be so? Well, first of all, because during the times of the USSR, we lived in the environment of collectivization after the perestroika, and in the last 20 years, what happened was that nobody became interested in the public. The private becomes more important for people, and this is one of the problems that the pro bono institution has to deal with. When we talk about pro bono, then Russia is at the periphery of this problem, and it's not only the citizens but also a lot of lawyers. When you talk to them about pro bono, they react very differently. Dmitry mentioned that that it is very specific to America, but sometimes, when I was talking about pro bono, they thought I was talking about U2 and the lead singer Bono. It's you can laugh, but again, this is very indicative of the scale of the problem. But if we're talking about pro bono and free legal aid, of course, I believe that these two things are intrinsically different. If you're talking about free legal aid, then free legal aid is a value which government has to provide, but pro bono has or carries public value. That's why the legal nature of pro bono goes much deeper. This institution is even more important because it is pro bono which develops the civil society, which develops the civilization and makes it truly global. But we have to admit that what we need in Russia is not pro bono globalization, but pro bono implementation. And pro bono implementation has to go through us, through lawyers, when we recognize that this is something that needs to be done, and only then we'll start seeing certain achievements. Pro bono, again, is a legal form which would become yet another mechanism, yet another guarantee of constitutional rights of our citizens. As we know, we have case law, we have the set of laws, but again, pro bono has to be witnessed in the behavior of our citizens. This is something that we do not really see today. And if you go back to Dmitry's slides, if you remember, he had some countries highlighted in light blue. And he said that pro bono in one of its forms exists almost everywhere. But again, if we see how frequent it happens, then again, we'll have to deal with a whole different set of colors, especially if we're talking about this country. So what needs to be done? I believe that, well, there are two ways to tackle the problem. One is a legislative way, and another is a public and legal way. If we talk about the legislative way, of course, we understand that in order for the citizens to receive qualified legal aid, it should be reimbursed. And I believe that one of the options is to introduce a subsidized legal aid or developing globalized network of free legal aid. And I do believe that this idea is a bit utopic. When we talk about Russia, it would generate too much cost and would be too hard to implement. And again, we shouldn't forget that sometimes the government also violates the rights of its citizens. And the government also has to help or has to support. Sometimes it creates an intrinsic conflict of interest, and this is something that we have to acknowledge. When we talk about the gray zone, and when we say that sometimes the government prefers not to regulate the situation, but it tries to live in this gray zone. Well, I have to say that we shouldn't forget that when we talk about constitutional law or the law of our citizens, this is not a gift from the state. The state has to recognize the right and to guarantee.
So this is the basic thing. It doesn't grant the right. It is immanent, like a spine. It is not transcendental. So the state also has to remember it always. As the second trend, introduction of pro bono standards. It's clear that now each one is taking his own risk, but that is not probably correct, and the valuable assistance of the state might consist in the following: to help introducing a certain standard of rendering pro bono aid. How this should be done? Probably the colleagues from the Federal Bar Association can help us, and it might become just a podium to become a legislator for pro bono and regulate it. And the third trend, which the law has always discussed, is legitimation of the success royalty. When a lawyer helps to restore the disturbed right, he has a risk, and finally he has a certain right to remuneration at the expense of delinquent when he has restored the right. But the legislative procedure is secondary. We have to recognize it. The most important thing is public legal trend, when everyone recognizes, the law is primarily recognized that for the right of exclusively work in the field of the right, you have to help the society, you have to help the community, and then gradually you will become a winner. As to the legislators and the regulation norms, they might be helpful, but not vice versa, according to me. It is more important to develop the legal culture, and this is scrupulous that has been taken out from the bag, and that it will be easier for us to proceed further. So we lawyers have to select one of the possible trends and start moving as quickly as possible, because we don't want Russia to just remain the best corner from the viewpoint of pro bono. And our main task is to overcome the problems in society, when we'll be able to talk about pro bono and globalization of pro bono. Now let us start at least implementing it. Thank you.
I think that Konstantin's presentation leads very nicely into our first set of questions, which I'm going to read very quickly, and then I'm going to comment on what Konstantin has just said. So our first set of questions says, has pro bono gone global? Is there a common global standard or definition of pro bono legal services? Should there be international norms, mandatory or suggested, for the expected levels of pro bono services? What are the key difficulties or factors limiting penetration of pro bono? Are there limits to globalization? Now, in those questions, the one I'd sort of like to focus on is the one in the middle, that is, should there be international norms, mandatory or suggested? And to come back to Konstantin's presentation, I think that all of you are very well aware of the discussions that are being held here today and have been held already now for a number of years about the regulation of the legal profession in Russia, and in particular what's called the monopolization of the profession, the move to require all lawyers practicing in Russia to be a part of the bar system and to take an exam in order to establish a minimum level of qualification. And in my mind, although I agree with Konstantin that in general the most important factor in pro bono is the motivation that comes from your heart, from your gut, that you feel that you've gotten a lot from your profession, financially, emotionally, etc., and that you need to give something back to the society. But in my mind, once you establish a monopoly of the profession, then we turn more towards the government regulation side. And when you have for instance, what's called in Russia a natural monopoly, or any type of a monopoly, then it's the responsibility of the government to impose a higher level of regulation. So then the question becomes, well, what sort of regulation would one have in mind? And in my personal view, at least, one should have some sort of a recommendation in the Code of Professional Ethics, which the Russian Federation has adopted. Maybe this is because of my personal background as a New York lawyer, where in the Rules of Professional Ethics of the Bar of the State of New York, all lawyers are encouraged to dedicate 15% of their time. And I noticed that this is quite a bit more than Dmitry mentioned with the 6 or 10%. And the question then becomes, should this at some point even move into a mandatory kind of a requirement rather than just a recommendation or an exhortation to attorneys to provide more pro bono services? I personally take a radical view and think that at some point, we're not there yet, either in Russia or elsewhere, one should move to a mandatory standard. And again, I think this is a necessary consequence of the monopolization of the profession, just as continuing legal education and other things are. So with that, I'd like to open it up for other comments on this first topic. Ozgur?
Okay, so I want to comment on whether pro bono should be made mandatory. In order to answer this question, we need to look what we're trying to achieve by making it mandatory. So when we look what we're trying to achieve with pro bono, we're trying to facilitate access to justice. That's why law firms are doing pro bono, because 9 out of 10 CEOs think that business should have a social purpose. And a law firm, or the lawyers, the social purpose we can have is to make access to justice possible, facilitated. And in order to do that, we want to do pro bono, but we need to look at the society. So is this current legal system or the existing legal aid is catching everyone who needs access to justice? Is there anybody falling through the cracks? And if the answer is yes, then by making pro bono mandatory, we can catch these people, we can fill in these cracks. If the answer is no, because the country is very well to legal aid, works perfectly well, the legal aid lawyers are super well equipped and have all the resources they need, then there is no need to make pro bono mandatory there, because then where will we find the opportunities? So I think a research or a study on, who is falling through the cracks of the legal system and how is it so that their legal needs are not met will help us answer this question. I think we should do that. So I am going to start working on it when I go back to the office.
Okay, well, I sort of have a somewhat different approach, Ozgur, which is that it seems to me that there will never be enough pro bono services. There are always needs that will fall through the cracks, as you say, even in the most perfect society. So my personal view is that the goal, being somewhat of an extremist or a maximalist, the goal is that every attorney everywhere in the world should dedicate a portion of his or her time to pro bono. And then the question becomes, how should one encourage that? And at this point, what I think I'd like to do is to give the floor to Yelena Dobrahutova. Yelena has been a panelist on this session before. She's a professor at St. Petersburg State University law faculty and has been one of the most active people in the Russian Federation, in the academic world in particular. Is there a microphone? In the clinical legal programs, and really has some exciting things to tell us about encouraging students. I should add, before I turn the floor over to Yelena, that in the state of New York, an experiment was started several years ago to require, it's the first time to my knowledge that any jurisdiction in the world has required pro bono, and it's now, it was imposed by the Court of Appeals, so not by the legislature, so within the court system, a mandatory 50 hours of pro bono services is a requirement to graduate from any law school now in the state of New York. That doesn't sound like a lot, frankly, 50 hours, but bear in mind that it's almost always in the third and last year of law school, so really it's for 1 year. So with that, Yelena.
Thank you, Glenn. I would like to thank for the possibility to make a statement. I have congratulated Glenn personally that we have restored the discussion of pro bono problems under the legal forum, and we have provocatively formulated the problems on globalization of pro bono. That is a theme with a shifted center of gravity. We can speak about two definitions. What is pro bono? Is pro bono a unified catch over and universal mechanism? And what is pro bono? Is it just everything to grow maize, as there was a motto in at one time in the Soviet Union, or does it mean diversity? The main thing is to have that element. I'm not going to talk about the activity of the students of the law clinic of St. Petersburg State University, of which I have been the head for 18 years, and during 18 years we didn't have a single complaint in respect of the quality. We're quite sure of our quality of providing legal services, and we issue a written memorandum to each the customer with the resolution on his legal condition, and we develop all the possible options and legal analysis and clear algorithm with supportive legal documents for each step of implementation of this advice. We have to be quite confident that we have done high quality work so that these written documents will be issued to the customers and will be kept in our archives. If the customer loses it, we might make a copy from the original memorandum. He'll be able to realize it in future. Now I'm going to talk about a different theme. This year I had convened a section at the Youth Legal Forum. That is the sixth legal forum. Despite the fact that this is the sixth forum, it has become a satellite event of the adult St. Petersburg Legal Forum. There were 10 sections, and they had similar names, similar to that of the adult forum. I was convening the section pro bono globalization, and our experts agreed on the following. Glenn, we worked for 3 hours. We had 11 presentations, and within 1 hour, we listened to 11 presentations. They were panoramic presentations, and we visited different countries and continents. We didn't visit Australia and Antarctica, so we'll go there next year. And we kept Australia for the next year. Glenn, we have prepared 10 young experts with a fresh views and with good absorption into pro bono themes. Having visited all the continents, we concentrated on the European countries. The students came to the following conclusions. The questions which were formulated by Glenn were also formulated by the young people. First, should the participation in pro bono be mandatory or voluntary? The answer in free discussion of all the delegates of the section of the International Youth Legal Forum, of course, based on a goodwill, but and I'm going to send, well, my opinion to my colleague, the Dribian. But if there is a question just to expand pro bono, there should be some mandatory component. Probably that will be self-duty initially. Our student asked the question, how should we regulate the activity under pro bono, using regulatory official regulation or using ethical codes? And their review panoramic presentations showed a very interesting dynamics. Let us take the USA, since there was more information about organization and evolution of pro bono phenomena in the USA. So everything started with the ethical code, then type rules appeared. Dmitry, probably you're correct if I'm wrong. Then standards appeared on rendering pro bono aid, and finally it ended in the Declaration of Principles. From the moral and ethical general categories, they passed on to the regulatory, normative, to technological, to quality, and then we raised to the height of the moral recognition and declarational mottos. Our students said that discipline or self-duty, what will promote the lawyer or advocate to participate in pro bono activities? They said net. The moral just initiative, and I will support my colleague the Brinian when he said that the legal culture of the entire society depends on the legal culture of the lawyers, and young lawyers also had the same opinion. Legal culture and high moral and legal culture of the lawyer, morality is a part of professionalism of the law. Only it will ensure the agency of voluntary and high-quality legal aid. As to addressing Europe, we studied the sources in different languages. Our students mostly use the French language. We discussed the USA of the 19th century, and my students said found 13th and 14th century sources in French concerning the evolution and origin of pro bono. Almost for 900 years, the European culture has been responding to the summons that it is necessary to provide legal aid by professional lawyers on a voluntary basis. And the students asked whether it should be done free or for money, whether the law should provide such aid freely or for money. And that was not an accidental question. When we came back to the European continent, having visited all other continents, we revealed certain principles, characteristic for different countries of Europe. In Europe, the students found more than 10 models of providing pro bono aid. Their common feature is participation of the state in the activities of pro bono, and the share of that participation is diverse. In some countries, the state totally finances legal aid offered to citizens on a free basis. It is financing it for the lawyers. In some countries, in most of the countries, the state subsidizes legal aid, and it either participates as a co-coordinator of pro bono models in the European space, along with the state, which coordinates or determines certain methodological recommendations or quality requirements of organization of the aid. The state also proceeds from the assistance, non-public organizations. These might be organizations of professional communities, lawyers, professional lawyers, or any other non-commercial organizations and even public organizations. There are European countries where in the system of providing legal aid, both under mandatory, state subsidized, and pro bono aid, these are two different parts, free state aid and pro bono, there are two hearts or two coordinators, the state and non-state, and everything operates well. The systematic character of organization of free legal aid is characteristic of the European space. In addition, in the European space, we have this division of functions between the participants of the systems. There is primary filtration. So first, the application is submitted for free legal aid. They are assessed whether the lawyers can work there, or they are submitted to the bar community and other professionals, or they look for the lawyers throughout the system of the free legal aid, or another procedure of sharing the duties under this cooperation system under a certain country. Primary interviewing and consultancy is done by some participants, for instance, legal clinics of educational institutions, as to the representative of the court of law and other types of serious legal aid. That is done by professionals of high level with significant experience. My students determine the interrelation. If there is insufficient compensation of the activity of the lawyers in the system of pro bono, naturally, the lawyers have two options for solving the problem: either to find some additional sources and pay additionally to what has been done by the state. And for instance, there is subsidized assistance, but that is not the only source. The lawyers take some additional money and add to the funding of the state, or the lawyers will proceed as follows. They say, let us correlate the price and professionals, the price of extra payment and the professionalism of the specialists, and they send less qualified lawyers to work at pro bono. And my students are young, they say that is not good. Now, being a moderator of the section, I think that the two basic conclusions can be drawn from that section. First conclusion: the state undoubtedly has to participate in organization and promotion of different mechanisms guaranteeing the rights of personality at any part of the space under its jurisdiction, and it is clear. But when we're speaking about the state provision, we're also talking about the budgetary support. It will never be sufficient, not because the state is poor, because life is much rich. Evolution of legal problems proceeds much quicker than the changes in the state, public budget and federal law.
That is why, of course, the participation of other stakeholders, of other participants who can react to the change of request in a more rapid manner, who can provide finances more swiftly, finances for the guaranteed legal help. Well, again, this participation is something that has to be. That's why when we're talking about free legal aid, it has to exist in any society. But the model for such free legal aid should correspond to the moral state of the society and to the state of its legal system. When we talk about the participation of the government or the state, it should be done through a legal and political consensus within national borders. And if we're talking about globalization, then as some of you already know, some of you who know me personally, well, you've heard about it from me, you know that my opinion is to look at the effects of free legal aid through the client's eyes. As you know, we have Law 324, which was passed in 2011 in the Russian Federation, and the law basically focuses on instances and subjects, but it doesn't really monitor how many times has an individual contacted the sources of free legal aid. But again, this system-based approach allows me to see that people actually do complain about inadequate legal services or about unqualified legal services. So the system does give us a mechanism for mutual control. This is an important thing. And again, pro bono is a component which always reveals the issue of quality. If there is no pro bono component, we can not really create a system of free legal aid, in my opinion. Of course, we can debate this issue if you'd like, but at the same time, the pro bono system, what it also highlights, it highlights the issue of quality, the quality of legal services. You know, Article 48 of the Russian Constitution states that each citizen has a right to access qualified legal services, comma, and it says that these services might be provided on a free basis, and this is a condition. Thank you very much for your attention.
That's a good lead-in into a number of our other questions, and we've discussed a little bit the role of clinical legal programs, the possibility of incorporating provisions into the ethical norms, either of a recommendatory nature or of a mandatory nature. There are a number of other mechanisms that have played a substantial role, or could play a substantial role in the penetration of pro bono services. For instance, in Russia, but actually all around the world. So there are three in particular that I would like to throw out for discussion, and then turn the floor over initially to Kendall Coffey. One of the ways in which pro bono legal services are encouraged in the U.S. is through the judiciary, through the court system. I've mentioned, for instance, the New York State Court of Appeals initiative of requiring mandatory pro bono service during law school as a condition of graduation. But the judiciary plays a larger role than that in the pro bono process in both the UK and the US. In addition, of course, bar associations or advokatska palata can play an enormous role in training and then implementing pro bono legal services. And Konstantin, in his remarks, mentioned the role that the Federal Bar Association could play, but that's not limited to the Federal Bar Association. Every advokatska palata, every bar association in the Russian Federation should be playing an active role in promoting pro bono services, in training lawyers, in helping lawyers to take on appropriate cases, in maintaining quality levels, etc. And also one other aspect that is quite important here in Russia, which could be a very important area for pro bono legal services, is the ombudsmen, which have been appointed throughout the Russian Federation. And there are, as I understand it, two types of ombudsmen. There is the ombudsman for entrepreneurs, and then there's the ombudsman for human rights. So first of all, I'll let Kendall discuss. I should mention that Kendall is a member of the committee in Florida. You can give me the exact name, Kendall, which reviews judicial nominations. So although he's not a judge, I don't know if we have any judges in the audience today, but in any case, Kendall is very close. Yes, we do. We have one European judge. But in any case, let me turn the floor over to Kendall.
It is a privilege to be here. It's a privilege to review the applicants for people who want to be judges, because it makes me very popular for a period. America is not a success story when it comes to services for the poor. It's a work in progress with a very, very long way to go. Despite the programs that provide legal services by paid lawyers, such as Legal Services Corporation, despite a lot of pro bono voluntary programs, the vast majority of people who need help to keep their home, to not be thrown out of their apartment, to get perhaps government services or government entitlements that they have a right to, can't get it. So it's a very, very big challenge, and as the senator said, the key is how to implement this. There are three items that I would draw from our experience that might be of interest in terms of roles that can be part of a solution, although again, only a small part of the solution so far. Bar associations can help, they can recruit, and they can give recognition to those who do pro bono. But I would say that overall, their contributions have been significant, but not enormous in trying to move toward a problem. And bar associations have resisted mandatory pro bono programs. So they are not a source of moving us in that direction, and that's why I think an international norm, an international standard could be something that elevates the efforts of us all. Law schools are starting to have a positive role. As Glenn mentioned, in New York, they have mandatory pro bono requirements for graduation. In a study of about 180 US law schools, close to 50 require pro bono hours before graduating law school. And it ranges from 20 to 70. But it's significant, and it's moving in the right direction. And I think it tells future lawyers that this is part of what they do, and perhaps informs future lawyers that this is a very worthwhile and rewarding experience. But where I think some of the strongest support is from the judges. Glenn mentioned the chief judge in New York, who has issued an order requiring future lawyers to have 50 lawyers. I think mandatory programs are simply much more meaningful with a huge problem that we're not meeting. In Florida, we attempted mandatory pro bono. I was part of a group that asked the Supreme Court to do it, but the court instead chose to have mandatory reporting requirements. And I'm not convinced that simply putting on a form whether, in your own opinion, you do enough is making a big impact. So, to summarize, I think there is progress. We have a long ways to go, and there are contributions that each of the components, the professional associations, certainly the law schools, and more the judiciary itself can play in contributing to solutions to what is clearly a serious worldwide challenge.
Если можно, просто очень короткий комментарий по поводу обязательного про боно.
I just have a comment on the mandatory pro bono. As you can see, even in the state of New York, in the USA, again, the opinions really differ on the subject, but I have to underline the pro bono as part of culture, as an understanding of the value of the legal profession. Something like this existed in America for at least 100 years. And again, the pro bono principle of the American Bar Association was passed in the 1970s. And of course, it makes no point for us to make pro bono mandatory in Russia, but you probably remember it used to be, well, more or less mandatory during the Soviet times or at the beginning of the perestroika, when the legal aid was provided basically for free on criminal cases. And I have to say that even some attorneys were reluctant to provide free legal aid, so basically they would just make a monetary contribution or pay those people who were willing to do it. And of course, when we talk about legislative introduction of mandatory pro bono, if we talk about the documents from the Federal Bar Association, I think that it is way too early to talk about that. But what we can do, maybe we can pass a declaration as an intent of our legal profession, as our moral obligation that we have for the society. I mean, this declaration is something that could find support in the Federal Bar Association, in the Ministry of Justice, but I cannot. I do not really think that we can truly introduce these mandatory pro bono hours here right now.
Gulen from Samara to comment on all of the aspects of promotion of pro bono. I forgot to mention in introducing Dmitry that in addition to being managing partner of one of the leading law firms in Russia, he's also a member of the faculty of one of the law schools in Samara, so he has the perspective also from the law school side and the teaching side. And what ways, Dmitry, do you see as being the most effective for promoting pro bono legal services, particularly in the Russian regions, where I think the need perhaps is even greater than in the so-called center?
Спасибо, Глен. Добрый день, коллеги.
Thank you very much, Glenn. Good afternoon, dear colleagues. I would first like to thank the organizers for the interest to the pro bono topic, which is demonstrated during this forum, and this is something that I hold very dear and close to my heart. And if I talk about my experience when I participated in different fora, when I participated in different debate platforms, I do believe that these fora provide a very great platforms for discussion, especially because we have such distinguished experts present on our panel. But I would like to say that I personally believe that currently Russia is part of the globalized pro bono movement, and here I have to disagree with my colleague who is a little bit skeptical on the issue. Of course, I understand that my opinion is subjective, but let me give you a couple of facts that I base my opinion on and why I think that Russia is part of the globalized pro bono movement. First of all, is that we do have the practice of providing free legal aid. This is something that I see my colleagues are doing. I see that more and more lawyers, more and more bar associations, international Russian ones, present in Russia, they do adhere to pro bono services and pro bono practice. And again, what we see that the geography of the pro bono services is expanding. It is not only being provided in Moscow and St. Petersburg, where all large law firms are concentrated, but we see pro bono services in Samara, Novosibirsk, Rostov. So the geography is expanding, and I do believe that the instances of pro bono services are increasing. The second factor is that Russia is currently a participant of international fora on pro bono legal services. I personally took part in two forums which were held in 2012 in Madrid and in 2013 in Poland, and I was very pleasantly surprised to see how many representatives were attending from Russia. I also believe that it is quite a good indicator of our involvement in the pro bono movement. And another thing I would like to underline is that what we have in Russia, we have functioning NGOs which are also facilitating or fostering pro bono services. Dmitry Shabelnikov is a representative of the Moscow office of the Institute of Public Interest. This is an NGO that our bureau cooperates very closely with, and I have to say that I do not really think that each country has a Pelnet office, and I do think that Pelnet is probably one of the most effective NGOs in the world which facilitates and promotes pro bono services. And let me just give you several facts and a bit of statistical information. We know that Pelnet works with 34 law firms, it works with 3 audit firms and 1 corporation. When I was getting ready for my speech today, I know that Pelnet implemented 350 projects in Russia, but Dmitry corrected me. Actually, currently it's 450 projects that they've implemented in Russia. So based on this, I can say that Russia is a fully fledged member of the pro bono movement, but I wouldn't, of course, say that the pro bono movement has deep historical roots. It is quite a young movement. But let me just give you a little bit of true statistics so that we are not looking at everything through rose-colored glasses. Of course, we do have a number of factors which hinder the promotion of pro bono, which hinder the facilitation of pro bono services. And these factors, they do persist, despite the fact that Russia actually have historical prerequisites for free legal aid. If you remember how the Russian attorney system was developing, you know that there was a practice, I believe it was 150 years ago, a practice of providing free legal services to the poor. So we do have some historical roots and some historical facts, but what is hindering the development of pro bono services in Russia? Well, first of all, I would have to say this is the attitude that we have from our colleagues, from our lawyers. A lot of people believe that pro bono is not worth their while. A lot of attorneys, a lot of lawyers believe that they provide professional legal services. Law firms believe that they have to make money and they shouldn't really do anything else. And I believe that it all comes down to legal education. Legal education, which we receive in this country, I would have to say that a lot of universities do not really teach students about the legal responsibility which their profession entails. They do not really tell them how law or the legal system influences the development of society. And what we have as a result, we have a lot of specialists who lack knowledge when it comes to social and legal responsibility of their profession. And I can give you another factor, maybe it is not as significant, but it still exists. Well, and this factor is legislative barriers for pro bono services. And I'm talking first and foremost about taxation of pro bono services. If you look at the taxation or the tax law, you can see that a legal firm which provides free legal aid or free legal services still has to pay VAT, and the person who receives such free legal services, they receive an income on which they also have to pay taxes. Of course, I cannot really recall a single case when the tax office would really take an interest in such cases, but at least there is this legislative basis, and I think that we can only avoid this taxation situation if we really formalize it as charity. But I wouldn't think that anybody would bother to go through all of the loops to make it look like charity. And another thing that I wanted to underline, I was very pleasantly surprised to hear about all of the facts that Yelena Dobrohodova told us today, and I'm truly impressed, and I'm by everything that they're doing in St. Petersburg. Again, this is something that we are truly inspired by in Samara. We talk a lot about pro bono in Samara, and I see the sparkle in my students' eyes when we talk about pro bono.
In the quality and quantity that is provided at St. Petersburg University, that is really amazing. And to conclude, I would like to note that I liked the words stated by Gleb Cornelia, who stated that pro bono should come from your heart, so that you would like to provide that free aid. It seemed to me that in the course of our discussion, probably, well, if it were not certain misunderstanding concerning pro bono and subsidized free legal aid, there was a certain mixture. Pro bono initially, by its nature, is exclusively based, is free of charge without any remuneration, particularly monetary remuneration. In concluding my presentation, I would like just to ask a question. If pro bono means charity, can it be paid for and mandatory? Thank you.
I'd like to turn the floor over for a moment to Konstantin and then to Christos.
Спасибо большое, Дмитрий, за выступление. Но
Thank you very much, Dmitry, for your statement. But I will persist. I am optimistic, but if an optimist says that a glass is half empty, that is really important. And we might pronounce the word halva 3 times, but your mouth will not feel tasty. Human rights are infringed on, violated on a mass basis. That is life. But the mechanism or restoration of those disturbed rights should be available. And pro bono is one of the underestimated mechanisms, which in Russia is the incipient stage. Well, such bright things appear, and that's really great. Thank to Dmitry Shebilin, because he's right track, he's an enlightener. But you have heard a lot. Do you hear a lot about pro bono cases? Do you hear regularly? I doubt it. 2 colleagues have come here, Valery Zinchenko sitting at the back, and Alexei Davalin. I will tell you a story. 3 years ago, St. Petersburg policeman killed a teenager, beating him with a stick. They gave 90 beats to him, and then they wanted to convict him of robbery after his death, just to provide the grounds for this abominable situation. The journalists in St. Petersburg found that material. They addressed their colleagues, and post-mortem they protected the dignity of that boy, and the policemen were punished. And I'm sure that after that my colleagues tried just that is really your legal pleasure when you are thanked for sharing your knowledge free of charge. Such cases are not so numerous. I know my colleagues who levied some millions from the medical university for the damage caused by a baby in the course of delivery, as a result of which he died. That was an unprecedented story. It was in Petersburg, but such cases are quite few. And if we try to convince us that that is globalization, that will not be too correct. Let us give a more distinct diagnosis to each other, then we'll manage. Just a brief statement. Konstantin touched on a very important issue related with making aware on the activity of pro bono. Repeatedly, I heard an opinion that pro bono project should not be covered by mass media. There is nothing to boast of, as they say. I have a reverse opinion. These projects that were implemented, pro bono project, their coverage will make it possible to introduce pro bono practice more extensively. For instance, colleagues after a certain forum join this movement, or a certain discussion will join this movement, and it becomes operational. So this should be done. We have to come together and to discuss it.
Very much. I do not want to go into the discussion between Dmitry and Konstantin about how to regulate that internally. But since one of the questions was whether there is a room for international regulations, I would like to say something about that. The Council of Europe has, the Committee on the Efficiency of Justice of the Council of Europe has estimated the amount of free legal aid on average spent in Council of Europe member states to go at about 140 million euros per year. And this is what is provided for in the budget of the member states. The figures that have been given by Dmitry show that there is an extraordinary amount, an evaluation of the amount of the pro bono services globally. I believe that at least an important amount of this 380 million US dollars, I think you said, is spent in Europe. So from the Council of Europe perspective, for our 47 member states, I think that there is an enormous amount of economic effort that is made either by the private sector or from the public sector to ensure justice. It is a sector that is developing, it is necessary, it is absolutely essential to guarantee human rights and justice. There is absolutely no reason not to regulate these aspects. And if there is, I wouldn't of course go into saying that there is a possibility at this stage to have mandatory regulations. The systems are too varied, too different from one country to another to go into a strict regulation. But at least some aspects, like for instance, what Dmitry has just said, the other Dmitry, I mean Dmitry Samguin from the other side, about providing a favorable tax regime for law firms that exercise at least a certain level of provide a certain level of pro bono legal services. An obligation for member states to encourage or to impose to their national bar association in their codes of ethics to introduce the pro bono legal service regime, or at least to encourage them. A possibility or an obligation for member states to encourage, an obligation but to encourage, so it's to balance the mandatory aspects, to promote legal clinics. Perhaps also the setting up, the favoring of setting up, establishing voluntary organizations that would provide pro bono legal services, provided, of course, that these voluntary organizations will not be considered foreign agents or other problems that we have faced sometimes in some member states. This is, of course, these are areas where we can, and there is room, and there are real possibilities for the international community, at least at the European level, to regulate in a smooth, recommendatory, soft law, as we say, process. And I think that this is, for me at least, this discussion was extraordinarily useful, and I think also the same is true for the President of our Committee for Legal Cooperation. We try to bring this message, the concerns and the opportunities that you have raised during this discussion, back to Strasbourg and launch this discussion there too. Thank you.
Okay, thank you, Christos. Colleagues, we don't have that much time. We have about another 10 minutes. Of course, if there are any comments from the floor, questions, comments, statements from the floor, please raise your hand and we'd be happy to have you. I think even though we haven't gone one by one through the questions, we've hit on most of them, and it brings us to the last and maybe the most important question of the day, which is how does pro bono fit into the overall picture, the bigger picture of the issue of access to justice worldwide. And for this, I would like to turn the floor over to Özgür from Istanbul, who actually suggested this. Really? I'm terribly sorry. In any case, to Özgür from the Paris office of DLA, who raised this issue in our internal discussions. And really, I would argue that this is really the fundamental question that we all face. In my mind, all lawyers have many obligations. These obligations come with the right to practice law. The obligations are to improve the legal system, to improve the administration of justice, and of course to assure equal access to all citizens of all countries of the world to judicial recourse, to judicial and legal support. So, Özgür?
Okay, thank you. I'll be brief. So access to justice is about ensuring people have legal representation. So legal aid does that also. Here, the question we need to ask ourselves is how pro bono is going to complement that, how it's going to work with legal aid, because sometimes the discussion is pro bono taking resources away from legal aid? If we put so much emphasis on pro bono, will legal aid dwindle, or how much should the governments do, how much should the private sector do? And then when we frame the questions like that, it looks like we're getting into kind of like a clash, like a debate. We should turn it around, and then we should talk about how these two things will complement each other, how they're going to work together, because there are certain strengths that pro bono has and certain strengths that legal aid has. Legal aid has the strength of being reliable, readily available, and can tackle urgent and difficult matters, whereas pro bono has the advantage of having highly developed skills and an international reach. So if we put these together in a country, all the people who I mentioned fall through the cracks will not fall through the cracks anymore. So to be able to answer this question, we need to look at individual countries. For example, there are countries where legal aid doesn't exist. So then the question is, how can pro bono help the establishment of a legal aid system and complement it? For the countries where legal aid exists but is not effective, there are long queues, lawyers cannot do a good job. they have heavy workload. In those countries, the question is how can pro bono help the legal aid to be more effective? In the countries where legal aid is working well and effective and covering everyone, maybe their pro bono should focus on improving capacity of NGOs or find itself another purpose. But we need to think along the lines of what is not working where and how can we come in to help out.
Okay. I think maybe we should have all of the panel and the audience comment on this particular topic, which sort of encompasses the whole... Я думаю, что может меня...
The interpreters will not hear you without the microphone. I would like to suggest to the panelists and to the participants to continue their discussion. I've been talking too much. Just to conclude, what else I would add? You should think that the legislator, such as myself, would like to regulate everything. I don't think that everything should be regulated by the legislative text. What I was speaking about, if we mean skilled, qualified legal aid and pro bono standardization, I think that skilled legal aid in Russia should be embodied. And that is not the monopoly of the advocate. Currently, skilled legal aid in the pure form doesn't exist. So if my colleagues, advocates, will be able to solve that task, that will be an advantage. And probably in the Bar Association, among the advocates, they will be introducing certain standards for pro bono aid. You should be based on the principle do not harm, because not kind of aid will be good. Do not harm when you provide pro bono aid.
A comment about how important all this discussion is. Pro bono really makes us different from other professions in a very important way for the reasons Glenn described. It also, having a common international standard and a sense of it, helps us connect better to each other, because it's all part of our identity as lawyers, our identity with a sense of public service. And I think we're very important to each other, and we're very important really more broadly to the world. We represent the rule of law, solving problems through principles of the rule of law. And I think access to justice for everyone, and our identity and our profession being part of that, is what makes us better, what makes us unique, and what helps us better connect to each other.
I'm not sure, извините, я не уверен, что я понимаю, о каком вопросе мы сейчас говорим. Вот что я хотел сказать, я тут слышал...
I'm not sure that I really understand what it is that we're talking about, but I've heard you mentioning a number of international standards for pro bono services. I wanted to say that we do have the IBA pro bono declaration, and we have a number of other declarations. Some of them even contain more detail to the principle of 6.1. There is an addendum to the principle 6.1 of the American Associations of Lawyers, which details how the practice of law firms should be structured, how the legal society should provide support to pro bono services. Of course, it is all in the American context, but we are planning to publish a brochure on the Advanced Center, and it will be done in the context of the pro bono declaration, We will try and make it more universal. We will publish it on our website. After that, we actually have an idea and a plan, not just to translate it into Russian, but actually to attract Russian lawyers who have experiences in provision of pro bono services, so we can adapt it to our experience, so we can adapt it to the Russian conditions, so we can basically give recommendations on how a law firm can organize pro bono practice, especially when it comes to management, budgeting, and so on, how they can find the money, how they can basically organize the services, so such standards do exist. And another thing I wanted to mention is something that I was talking about my presentation, and I have to say that you can actually find it in an article in the journal Zakon in Russian. It is distributed at the forum today, so you can find more information about it.
We've been asked to clear the hall for the next session, but before we do, I'd like to conclude with a few remarks. First of all, I'd like to say that I think that Kendall said this to a certain extent, but forums of this kind and pro bono sessions in forums of this kind plays an extremely important role in many respects, both in encouraging pro bono, in discussing the problems that need to be overcome, such as the taxation issue that was raised, in discussing how to implement proper standards for pro bono work. And Dmitry, for instance, Dmitry Samigulin was at the recent legal forum in Novosibirsk, which I've attended in the past as well, at which roughly 100 people attended the pro bono session. There are similar fora that are organized all throughout Russia. For instance, with Konstantin Dobrynin's initiative, there's a very important forum coming up in a few days, or a week or two in Arkhangelsk. I hope that pro bono is discussed there. At the end of October 22nd to 24th, the Stepanovsky Papakul law firm in Minsk and Dentons are sponsoring a conference in Minsk, at which we also hope to attract colleagues from Russia and from Ukraine in particular, and we will certainly have a pro bono session there. And of course, as Dmitry mentioned, the PILNet annual conference in Rome in November, and most important of all in my mind, the first Russian Pro Bono Congress next spring. And I'd like to say that in my mind, even though we don't have as many people here today as we usually do, or as we had hoped, that each one of you I view as an ambassador, as someone who can assist all of us in bringing pro bono to our respective practices, whether it's in a large international firm, or a sole practitioner, or a law school, or a corporate legal department. All of us have a very important role to play. All of you have a very important role to play. So I'd like to thank you for coming to the session. I'd like to thank all of the members of the panel. I'd particularly like to thank the organizers of the International Legal Forum for having this session now for the third time. I hope very much that it will be at all of the sessions of the St. Petersburg International Legal Forum. And I'd also like to thank our translators. I don't listen to them usually, but I notice that they not only translate, but they have gestures and emphasis, and really are doing a terrific job. So thank you all, and have a good rest of the forum and a good time in St. Petersburg. Thank you.